6. Right to practice. Trick to remember, ASPIRE to practice. The right to practice is the statutory privilege that transforms an enrolled person into an advocate. It is governed primarily by Section 30 of the Advocates Act, 1961. Detailed explanation. 1. A absolute statutory right, Section 30. Description. The right to practice is not a common law privilege, but an explicit statutory right conferred by the Act. Significance. This gives the right a firm legal foundation, making it enforceable and ensuring it cannot be arbitrarily revoked by courts or other authorities without due process. 2. S. Scope. All courts and tribunals. Description. The right is comprehensive and national. An advocate can practice in all courts, Supreme Court, High Courts and subordinate courts, before any tribunal or other quasi-judicial authority, before any person or authority legally authorized to take evidence. Significance. It establishes a true all-India license, removing internal jurisdictional barriers for enrolled advocates. 3. P. Permission not required. Description. An enrolled advocate does not require separate permission or a separate wakalatnama, power of attorney, for each court appearance, as the enrollment certificate serves as the primary authorization. Exception. Senior advocates, text section 16, are subject to rules that may require them to be accompanied by a junior advocate. 4. I includes acting and pleading. Description. The right encompasses both acting, preparing documents, drafting petitions, and handling behind-the-scenes legal work. Pleading, representing the client and arguing the case in open court. Significance. This feature reflects the integration of the bar in India, consolidating the roles of a solicitor and a barrister into the single class of advocate. 5. R. Restrictions limited and specific. The right is not unchecked. It is subject to contempt of court, the court's inherent power to punish for contempt. Conduct rules, adherence to the standards of professional conduct and etiquette prescribed by the text BCI. Court's inherent power, the court's authority to regulate the appearance of advocates in the interest of justice. 6. E. Exclusive to enrolled advocates. Description. This right constitutes a protected monopoly. Only a person whose name is entered on the state roll of advocates is legally entitled to practice law. Significance. This professionalizes the field and protects the public from unqualified practitioners. Visual chart for right to practice. 7. Conduct of advocates. Trick to remember, DUTY-BCI for the framework of conduct. The conduct of advocates is governed by a robust framework enforced by the bar councils to ensure dignity and public trust. Detailed explanation. 1. D. Duties, the 4 pillars of professional ethics. An advocate's conduct is defined by their duties towards 4 key pillars. Duty to the court. As an officer of the court, the advocate must maintain dignity and respect, refrain from misleading the court, and be punctual. Duty to the client. The advocate is a fiduciary, a person in a position of trust. Key duties include upholding absolute confidentiality, privileged communication, being diligent, and handling client funds responsibly. Duty to opponents. The advocate must maintain cordial relations, carry out legitimate promises, and not negotiate directly with an opposing party who is already represented by counsel. Duty to public and colleagues. This includes refraining from advertising or touting, soliciting work, and maintaining dignity and ethical behavior even in private life. 2. U under Standards by BCI. Source: Section 49(1)(c) of the Act grants the Bar Council of India, text BCI, the power to frame specific rules detailing the standards of professional conduct and etiquette for all advocates. 3. T. Towards the framework in Chapter 2, Part 6 of BCI rules. The actual detailed code of conduct is laid out in Chapter 2, Part 6 of the text BCI. Rules which systematically elaborates on the do's and don'ts related to the 4 pillars of duties. 4. Why yoked to discipline? Misconduct. Any breach of these standards of conduct is termed professional misconduct. This includes actions directly related to the profession, e.g., misappropriating client funds, or other actions deemed unbefitting of an advocate, e.g., conviction for a crime of moral turpitude. 5. B. Bar Council's disciplinary power. The State Bar Council, text SBC, has the primary power, Section 35, to initiate disciplinary proceedings and investigate complaints. The Bar Council of India, text BCI, acts as the appellate authority, text Section 36, against the orders of the text SBC. 6. C. Consequences of misconduct. If found guilty, an advocate can face severe consequences. Reprimand, a formal warning. Suspension, suspension from practice for a specified period. Disbarment, removal of the advocate's name from the state roll, permanently revoking their right to practice. 7. I. Improper conduct equals misconduct. The core principle is that any conduct which is unbecoming of an advocate or harms the profession's reputation can be treated as misconduct, justifying disciplinary action. Visual chart for conduct of advocates. Final 20 mark answer structure. Question. Discuss the nature, scope and extent of the right to practice and explain the framework governing the conduct of advocates under the Advocates Act 1961. Ans. Introduction. The Advocates Act 1961 defines the professional life of a lawyer through two critical pillars: the right to practice, text section 30, which empowers them, and the code of conduct, text section 49, which regulates them. This dual framework ensures the legal profession is both independent and accountable. Part 1. The right to practice, text ASPIRE. Closing parenthesis. The right to practice is a statutory right conferred upon enrollment, making it legally enforceable and secure. Absolute statutory right, text A. It's a formal entitlement, not a mere court privilege. Scope. All courts and tribunals, text S. The right is nationwide, covering the Supreme Court, all high courts, subordinate courts, and any judicial or quasi-judicial authority. Permission not required. Text P. The advocate's enrollment certificate serves as the only authorization required. No separate court permission is needed. Includes acting and pleading. Text I. The right integrates both functions: drafting documents, acting, and arguing in court. Pleading, eliminating the historic barrister-solicitor divide. Restrictions are limited and specific. Text R. The right is balanced by the power of the courts to punish for contempt and the obligation to follow text BCI conduct rules. Exclusive to enrolled advocates. Text E. The right is a protected monopoly available only to those on the state roll, ensuring public protection from unqualified practice. Part 2. The conduct of advocates. Text DUTY. BCI. Closing parentheses. The conduct is regulated by the text BCI. Rules ensuring advocates function as officers of the court. 1. Duties, text D. An advocate's conduct is built on 4 pillars of duty: to the court, respect, no misleading; the client, confidentiality, diligence; the opponent, fairness, no direct negotiation; and the public colleagues, dignity, no touting. 2. Under, standards by BCI, text U. The authority to prescribe these standards of professional conduct and etiquette is granted by text section 49(1) C to the text BCI. 3. The framework in Chapter 2, Part 6, Text D. These rules contain the detailed code that governs all professional dealings. 4. Yoke to discipline, Text Y. Any breach of these standards constitutes professional misconduct. 5. Bar Council's disciplinary power, Text B. The text SBC acts as the primary disciplinary authority, Text Section 35, and the text BCI handles the appeals, Text Section 36. 6. Consequences improper conduct, Text C, by Text I. Misconduct results in severe punishments, ranging from reprimand to suspension or, in the most serious cases, disbarment, removal from the roll. Conclusion. In conclusion, the right to practice grants advocates the necessary power and independence, while the rigorous code of conduct ensures that this power is exercised ethically and responsibly. This self-regulatory mechanism is the key to maintaining the honor of the legal profession and public confidence in the administration of justice.